This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about malicious prosecution suits because they require a successful termination of the suit that you claim were maliciously prosecuted, and that you must also show outrageous conduct beyond the bounds of decency before you can proceed. Now, when a insured or person involved with an insurance company, like Sarah Steinmetz, filed a 5-count complaint against Lindsey Pickholtz and Gordon, alleging malicious prosecution, abuse of process, intentional infliction of emotional distress, and conspiracy to commit malicious prosecution because the defendants reported her to the Division of Insurance of the state of Florida with false statements and caused her to be arrested by the state in connection with those charges. The complaints detailed events spanning 2.5 years, beginning with the sale of Steinmetz's condominium to Pickholtz and Gordon. The relationship between the parties deteriorated after a prank call incident leading to fabricated evidence and legal actions against Steinmetz. In the case entitled Sarah Steinmetz versus Lindsey Pickholtz et al., the Florida Court of Appeal on June 11, 2025, resolved most of the issues relied upon in the appeal. The trial court dismissed Steinmetz's complaint with prejudice. Steinmetz appealed, arguing the trial court erred in its decision and denying her leave to amend. The appellate court affirmed the dismissal of the abuse of process and intentional infliction of emotional distress claims, but reversed the with prejudice designation and the dismissal of the remaining counts. The court concluded that Steinmetz's allegations were sufficient to overcome a motion to dismiss for malicious prosecution and civil conspiracy. The key points raised by the case started with, first, malicious prosecution. Steinmetz's allegations of fabricated evidence and lack of probable cause were deemed sufficient to support a claim for malicious prosecution. Civil conspiracy, the court found that Steinmetz's detailed allegations of an agreement between Pickholtz and Gordon to fabricate evidence and make false reports were adequate to support a civil conspiracy claim. With regard to abuse of process, the court affirmed the dismissal, but noted that Steinmetz should have been granted leave to amend. And finally, with regard to the intentional infliction of emotional distress, the court affirmed the dismissal of that claim, finding the allegations sufficient to meet the required standard. A bona fide termination is a critical element to proof of the tort of malicious prosecution since a very early date, and has been described as a precondition to the latter action. As Justice Scalia explained in the seminal case of Heck versus Humphrey, 512 U.S. 477, a 1994 decision, one element that must be alleged and proved in a malicious prosecution action is termination of the prior criminal proceedings in favor of the accused. Steinmetz failed to sufficiently allege that the voluntary dismissal of the civil injunction and the nolle prosequi of the criminal aggravated stalking case constituted bona fide terminations of the earlier proceeding, as it is required to support malicious prosecution claims. Generally, whether a voluntary dismissal or a noli pros constitutes a bona fide termination sufficient to support a claim for malicious prosecution prevents a factually dependent question, and therefore the issue is best suited for the jury as the fact finder, and so she can go forward with her malicious prosecution claim if the jury finds that there was in fact a true dismissal in favor of the plaintiff. Steinmetz alleged that Pickholtz, with Gordon's assistance, instigated the former proceedings with improper purpose and without probable cause. Intentional infliction of emotional distress, however, requires the following elements. 1. Intentional or reckless conduct. 2. Conduct outrageous beyond all bounds of decency. 3. Causation. And 4. Severe distress. The second prong is the gravamen of the tort. And while the anxiety and stress of being charged by the Division of Insurance Fraud with making false statements and being arrested by the state in connection with those charges is understandable, the actions of the defendants, the appellees' behavior in instigating and then allegedly falsely reporting to the Division of Insurance that fraud was committed. However, the Court of Appeals concluded the action is not the type of conduct that is so outrageous in character and extreme in degree as to go beyond the bounds of decency and be deemed utterly intolerable in a civilized society. And therefore, there would be problems with the defendant's charges. The case was reversed and remanded for further action. In my opinion, if an insurer or a citizen learns of an attempt at insurance fraud, they are obligated to report that suspicion to the Florida Division of Insurance Fraud. However, it is a tort to make such a report maliciously or in bad faith. Steinmetz claimed that she was falsely accused of fraud, was arrested by the Division of Insurance Fraud, who dismissed the charge and refused to prosecute. She then claimed, but was unable to establish, malicious prosecution, and the Court of Appeal concluded that the accusations were simply not outrageous beyond the bounds of decency. This video was adapted from my blog, Selma on Insurance, which is available free to anyone who clicks on the URL selma.com/blog. You can subscribe to the blog, and if you do, you will receive notice of every blog posting, usually 5, sometimes 6 a week, and gain access to the more than 5,100 blog postings. You can also subscribe to these videos, and if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. Please tell your friends and colleagues about this blog and these videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider subscribing for a very small fee to my Substack publication. Thank you for your attention.